How to disarm DHS in immigration court.
Hello, my name is lawyer Edwin Fogam. I have practiced immigration and other areas of the law in the United States for 28 years. Today, let us discuss how to disarm DHS in removal proceedings. DHS is Department of Homeland Security, and removal proceedings are proceedings that are initiated to refer a case to an immigration judge. So during these proceedings, the applicant or the respondent who has been referred to immigration court will need to testify and present testimony regarding their case, and the government lawyer will cross-examine them, and the judge may ask some questions. Now, the proceedings will depend on the relief that the foreign national or the respondent is seeking. A relief is the application that has been filed or what the respondent is asking the court to consider in order not to remove them from the United States. It may be employment-based, it may be a VAWA relief, it may be an adjustment of status based on any of these or based on marriage, or it may be an asylum claim. However, generally there will be testimony and questions. So what are the strategies you can use to disarm the DHS? DHS will have their lawyer in court, and these strategies I'm presenting to you can be used even if you are not represented, if you know how to go about it. But if you are represented by an attorney, you can share this with your lawyer during your strategy session, during your preparation session. The first strategy is analyze your case and know all the contradictory aspects of your case. When you know that, and after you know that, use that in your direct testimony. In other words, the lawyer should ask you those questions before the government even asks them, and clarify them. That's the first. So if you are representing yourself, you may want to talk about those things even before the lawyer asks them, the DHS lawyer asks of them, or before the judge asks you about them. That's the first strategy. Now, of course, this takes preparation and time, but it can be very effective if you are ready with them. The second strategy is anticipate DHS cross-examination question. See, after your testimony or after your lawyer asks you questions, DHS will have an opportunity to cross-examine you on what are the problematic aspects of your case. But if you anticipate these and make sure you talk about them, or if your lawyer is examining you, your lawyer should deal with those things upfront and ask you those things, and you clarify them even before DHS comes to cross-examine you. Now, this is the same thing with the judge, because the judge can also ask you questions. But in anticipating cross-examination questions, you'll be preparing yourself for the questions that the judge may ask you. So if you use these strategies very carefully, very well, it will help you in your case. I hope this was relevant information to you. And if you have any further questions, please do not hesitate. You can call us on 301-608-1555. Or you can send us an email. You can send it to info@fogamlaw.com. And always remember to understand the system. Do not fear it. Work with it and benefit from it. Thank you. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.